that he is the main financial provider. Unfortunately, his wife came down with an illness to where she was unable to work, so he was.
Is there any proof of that?
I don't have the proof for today, Your Honor.
Did you
But we
tell
are asking.
probation that he was having these issues?
I'm not aware if it's not notated in the.
Did you tell, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Marquis Bowden.
All right.
Pryor tried to explain why the program was not completed. Money problems, family pressure, a sick wife. But Judge Boyd did not move on from the explanation. She asked one simple thing. Where is the proof? Then she turned to the defendant and asked whether he ever told probation what was happening. That answer changed the whole tone of the hearing.
Y'all ready to proceed on the motion to revoke?
Yes.
Court is calling 2022 CR 6099, State of Texas versus Marquise. How do you pronounce your last name? Bozier. Could I have the parties announced for the record for the state?
Ashley Jones.
Defense.
Zachary Munoz.
And are you Marquise Tyree Bozier? Did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Marquise Tyree Bozier who was placed on deferred adjudication in 2022 CR 6099 on December 5th, 2022 for a period of 2 years for the offense of assault bodily injury? Is that you?
Yes, ma'am.
All right, state.
The state is proceeding on violation of condition number 4. Would you like me to read that?
Yes.
Violation of condition number 4 on the August 9th, 2024 supplement to the motion to enter adjudication of guilt. In Bexar County, Texas, the defendant Marquise Tyree Bozier, did then and there fail to report to the supervision officer as directed for the months of April, August, December of 2023 and March 2024. Violation of condition.
How do you plead to that, true or not true?
And Your Honor, I do apologize. The state is going to waive that condition. I read the wrong condition.
Okay.
So the state will be proceeding on violation of condition number 14G. That on or about the 23rd day of April 2024 in Bexar County, Texas, the defendant Marquise Tyree Bozier did then and there fail to comply with the instructions of the Battery and Intervention and Prevention Program, or BIP, as directed by the head or authorized personnel of that agency, in that the defendant did not provide proof of attendance in violation of condition number 14.
How do you plead to that, true or not true?
And the state will waive all remaining conditions in all supplements and original.
Any objection to the waivers?
No objection, Your Honor.
Did you understand by pleading true to violation 14G, the court could find it true, grant the motion, find you guilty, sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Knowing that, do you still wish to plead true to 14G? Court will find 14G true. Is there a proposed agreement?
There is, Your Honor.
Yes.
That agreement is to grant the state's motion to enter adjudication of guilt, adjudicate the defendant guilty, and sentence him to 237 days in the Bexar County Jail. That would be a JSAT, and we would ask that time and money.
All right. What has he done on probation?
Your Honor, my understanding is he did complete some of the courses. And he did pay some of the fines and fees.
Did he complete anything? Did he complete the Batterers Intervention Program?
No, Your Honor, that's why he pled true to that one. He enrolled, unfortunately, as of course well aware, it's quite time consuming and it's quite expensive in my client. Unfortunately, he has a wife and stepchildren that he is the main financial provider. Unfortunately, his wife came down with an illness to where she was unable to work, so he was.
Is there any proof of that?
I don't have the proof for today, Your Honor.
Did you tell probation that he was having these issues?
I'm not aware if it's not notated in the.
Did you tell, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Marquis Bowden.
All right, did you tell probation you were having difficulties? Did you tell them about issues concerning, is this your wife?
Yes, ma'am.
Did you tell them about that?
No, ma'am.
Okay. Did you complete anything on probation?
I believe it was, I had 2 courses. The BIP was the only one that I didn't complete. but everything that's not completed.
All right, so you completed the DOEP course? All right, the main course is the BIP, because that's the battery intervention course.
Yes, Your Honor. No, we understand, and that is why, you know, he has been in custody for 237 days. That's why we're asking. It's pled true to that violation. We're asking the court to accept that the current agreement of 237 days and hold that as a judgment satisfied for this case.
All right, and who is the,
The complainant is an ex-girlfriend from years ago, back in 2022 or earlier.
so has he had contact with her?
I've spoken with him prior, and no, he has not. He can go on the record, of course, and testify to saying that as well.
And Your Honor, just to clarify for the record, I just want to make something correct for the record. At least in one of the supplementals, it does allege that there is a violation for not completing the supplemental, for not completing the drug course. That is an allegation that the state is waiving.
Okay.
But I just wanted to have that in front of you.
All right, the court is going to grant the motion, find you guilty, revoke. There's an affirmative finding of family violence. There's to be no contact with the complainant. That's Danesha Gray, Danesha. There's going to be credit for any time served. The court will sentence you to 1 year in the Bexar County Jail. All right, did you review the document? And the court will not do a fine. Did you review the document entitled "The Trial Court Certification of Defendant's Rights to Appeal" with your attorney? Did you understand it and sign it? All right, did you review that document with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a conviction with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome. Court is calling 2024 CR 010117, State versus Eric Kelly. Can I have parties approach and announce for the record for the state? For the defense?
Robert Bears on behalf of the office of Kelly Green. Further campaign.
All right, and are you Mr. Kelly?
Yes, ma'am.
All right, do you have any objections to Attorney Barron standing in for Attorney Kelly?
No, ma'am.
Right. And I'll note for the record that the court is in receipt of the discovery acknowledgement. Counsel, have you received all of the discovery? Did you review it with your client? Court will find that the state is in compliance with discovery. Let me see here. I'm trying to find here we are. Mr. Kelly, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Hey, Judge.
State, are you proceeding on the indictment as presented?
Objection.
Did you review the court admonishments with your attorneys? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right. And count 2, the charge is aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
That's correct.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Correct.
That's yes or no?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
To assist in his defense, I believe he's confident to enter his plea.
Do you believe he was sane at the time of the offense?
I do.
Mr. Kelly, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
That's correct.
Court will find, yes or no?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 2. They're asking that your punishment be assessed at 2 years in the prison. Do you understand that if I find a deadly weapon was used, there will be an affirmative finding of deadly weapon?
Yes, ma'am.
And there are no applications. This is to run concurrent with County Court Cause number 708-473, 709-900. State will take in consideration 2024 CR 0497 and 2024 CR 5344. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Judge, there have not.
Then to the offense in count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers states exhibit number 1 and attachments.
There's no objection.
Did you review the waiver and stipulations with your attorneys? Did you understand it and sign it in all the appropriate places?
Correct. Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, so does anyone want to explain why the court should go forward with this agreement?
Judge, I'm not familiar with the facts of this case.
Judge Jason Garaham for the state,
Yes.
and Judge, in this particular case, I'm sorry, I just came in right now from out of court.
Mhm.
My question, I think your question was of why you should proceed with this,
Yes.
is that we've talked to the victim in this case, and we feel that this is an appropriate outcome in this case.
All right. So you've spoken with the complainant and they're aware of this outcome and they're in agreement with this outcome? All right, thank you.
Judge, just so you know as well, Mr. Kelly has been suffering from a lymphoma since he was a child, about 10. He's had a couple occurrences of it, and apparently it's rearing its head again. He has a lymph node in his eye that is significantly swollen or tumor-like, and probably going to need attention on that while he's in custody.
All right, court is finding you guilty. Court will sentence you to 2 years in the prison. Give you credit for any time served. There's an affirmative finding of deadly weapon. This is run concurrent with County Court Cause number 708-473, 709-900. Take in consideration 2024 CR 0497 and 2024 CR 5344. And there is to be no contact with the following. The first is the street location of Gateshead Road, Gateshead Road. That's San Antonio, Texas, 78251. And there's to be no contact with the following persons. Ryan Dekrone, Dekrone. Tamara Scrum. Marissa Magana, Magana. Anything?
Marissa Magana, she's not a complainant in this case. That's Mr. Kelly's girlfriend, fiance.
She's the co-defendant. Are you all married?
Yes, ma'am.
When were you all married?
We haven't finished the paperwork, but she's got issues.
As far as I know, and I checked the record just this morning, she was never a co-defendant in this case.
No, they have her,
In a fraudulent use or possession of ID case.
no, they have her listed as defendant number 2 in the,
They never
Paperwork.
charged her.
Never done it.
That's correct, Your Honor. I don't think she was ever indicted under this case. I mean, it is listed as like a suspect. I mean, not a suspect, like, as a co-defendant.
they said that suspect 2, which is her, was also found to be armed.
That I don't think they even ever charged her with it. They did charge her with fraudulent use or possession of ID stuff.
All right, while they look for that, there should be also no contact with Desiree Johnson. Itzel Lugo. Prudencio Benavides. Raymond Rangel. Norma Villarreal. Yes.
Okay, okay.
Yes.
Sorry. Judge, that case was sent over as a ag robbery, but it was rejected for further investigation. That's the extent of it. Usually further investigation means possibly insufficient evidence on her. But as far as I know, it's been rejected at a intake level by the DA's office.
All right. Then I'll remove that as a part of the sentence. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so we're off the record. You have all these health conditions. You need to start making better decisions with your life. You understand? As I'm going to tell you what I tell everybody else. We could not have funding for water or whatever it may be. They will always, and when I say they, the government will always find room to fit people at the Bexar County Jail and to fit people at the prison. There's always room at the prison.
For the cancer treatment as well.
What I'll do is I'll put on their therapeutic community, but you need to let them know that you have medical issues. They usually will have a medical clearance for you before you go. And so they'll see if there are some issues. All right.
Yes, ma'am.
All right. Good luck to you. Court is calling 2024 CR 007543, State of Texas versus Michael Egu. Could I have parties announce record for the state?
Andrew Harris Salem.
Defense
Tony Hernandez on behalf of Mr. Ugu.
and probation. This is an application. Thank you. Counsel, have you received all discovery? Did you review it with your client?
I have been.
Court will find that the state is in compliance with discovery. Mr. EU, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, and I believe there's a trial amendment on the indictment.
Right, state, are you proceeding on the indictment as presented?
No, Your Honor, state moves to amend the indictment to change the spelling of Mr. Wu's last name from UEWU to UGWU.
Any
No
objections?
objection,
Sir, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, you're charged with assault on a process server. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand that the court were to grant your application for deferred adjudication if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ego, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 4 years in the prison. There's a $1,500 fine. State is silent on your application for deferred adjudication. The state recommends community supervision. There's to be restitution of $250 to Beatrice Valdez. Did you understand that to be the plea?
Yes, Judge.
Defense is at the plea?
It is, Your Honor.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Judge.
Did you understand by citing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Judge.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 4 years and there be no contact with the complainant. Did you understand that is recommendation from the state and the court does not have to follow that recommendation?
Yes, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Containing exhibit 1 and attachments, Your Honor.
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Judge.
Did you understand that today the state will present evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Counsel, do you wish to proceed with sentencing?
We can, Your Honor.
All right, does your client have any criminal history?
He does, Your Honor. He's currently on deferred adjudication for an aggravated assault with a deadly weapon. The court granted his application for deferred adjudication. He seems to be doing very well on deferred adjudication. My understanding is he's finished the classes he's supposed to have done. He is behind on his fees, but it's been challenging for him to find jobs. But other than that, he's doing very well. He reports no UA problems or anything like that. He's doing quite well. This particular case predates the granting of the deferred adjudication on the other case. And it was, I guess, sealed for some reason because we didn't see it and the state didn't see it either.
Okay, all right, that explains things. All right, anything states you're silent on his application for deferred adjudication, so you're excused.
Thank you, Your Honor.
You're welcome. All right, this is what the court will do. The court will sentence you to 5 years deferred adjudication. There's to be a $1,500 fine that will be probated. Anger management. Proof of employment within 30 days. No employment as a home health care provider or with minors. Restitution of $250 and no contact with the complainant, Beatrice Valdez. Regular reporting by Zoom or in person. Regular random UAs. Field visits 1 time per month for 3 months. 200 hours of community service restitution. Probation, is there anything else? Is there anything else you need from the court to be successful?
I believe he already took the anger management class under the other probation.
He'll need to speak with probation. If that's been completed, then the court will deem it satisfied because this case predates the probation case.
And Judge, one question, is the additional community service hours, is that in addition to what he's already been given? Is
Yes.
that concurrent?
That's in addition.
That was
And if he wishes to pay off the community service hours, he can pay off the community service hours at $7.25 per hour.
Thank you, Judge.
And Judge, that was 200 hours?
Yes.
Thank
All right, I'm showing you what's entitled trial, excuse me.
I'm sorry, Judge, I thought we were.
No.
I'm sorry.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and sign it?
Yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
yes.
All right, we can go off the record. Here's the thing, when somebody comes to serve you papers, everybody's trying to do their job. This is what you can do. You can they'll put the papers in the door, or either you can tear it up after they leave, but you can't put your hands on anybody. You understand? All right, good luck.
Thank you.
These hearings show how Judge Boyd separates explanations from responsibility. In the first case, the defense gave a reason for noncompliance, but Judge Boyd looked for proof and communication. When the defendant admitted he had not told probation, the excuse lost strength. In the second case, personal hardship and health problems were raised, but Judge Boyd still made clear that consequences do not disappear when the record is serious. And in the final case, a plea ended with a practical warning. People doing their job cannot become the target of someone's frustration. That is the pattern in Judge Boyd's courtroom. Explanations may be heard, but they still have to survive the record. Comment which warning felt strongest, and subscribe for more real Texas courtroom breakdowns. Every ruling has a reason. Court Beacon TV shows you both.